Good evening, members. My name is Mary Tweskomwe, your host. I welcome you to today's criminal law Q&A session that is hosted by TMBEI advocates. I thank you for attending yet another week of community legal empowerment. Thank you for sparing your time and for being with us. Tonight, I wish to appreciate our weekly theme moderator, Miss Edith Kawategeki. Miss Edith is a researcher at TMBEI Advocates and a student at Victoria University, Kampala. She has guided the content and ensured we are addressing the most relevant criminal law issues that affect the public. And Miss Edith is part of the panelists for today. You're welcome, Miss Edith Kawategeki. I wish to appreciate our other panelists, Advocate Faith Arinda. You're most welcome, Counsel. And Daniel Ola, Head of Research at TMBEI Advocates and a student at Victoria University. You're most welcome, Daniel. Daniel is part of the panelists. So today's discussion, we are going to have 3 panelists. Shall have Advocate Faith, Daniel, and Edith. Behind the scenes, we have Ashri Creations. Ashri, I wish to thank Ashri Creations for ensuring a smooth delivery and professional quality online sessions that we see. Thank you very much. To our sponsor, Bay Investments, thank you for supporting the legal awareness and community education. We do not take your support for granted. I wish to recognize the entire TMBEI advocates and the Bay Investments Group for the continuous teamwork and commitment we are doing to serve the public. Thank you very much. Let's proceed with tonight's discussion. I will begin with Advocate Faith, and we shall discuss issues that are related to the practical day-to-day affairs. Issues to do with police arrests, the powers of police, the rights of suspects. Advocate Faith, Counsel, we wish to understand from you the circumstances that justify a lawful arrest in Uganda. Counsel Faith.
Thank you, Councillor Mary. Good evening to you all. So I will discuss what circumstances justify a lawful arrest in Uganda. An arrest is lawful only where the law gives the power to arrest and the officer or private person exercises that power within the limits that are set by the law, that is the Constitution. For an arrest to be lawful, we need an execution of a court order, or what you would call a warrant of arrest. That is to put into effect a valid warrant. There must be reasonable suspicion of a crime. When there is a reasonable suspicion of a crime, an arrest warrant by police may not be necessary. So, for example, under the Criminal Procedure Code and the Police Act, a police officer may arrest without a warrant where the officer has reasonable grounds to suspect that a person has committed a crime or is committing a crime or is about to commit an offense, that is listed under the law, or when an offense is in fact being committed, like you're in the process of committing an offense. So the officer must act within those statutory. Sorry, can you hear me?
Yes, we can hear you. Proceed.
Yes. So we also have an arrest by a private person. The Criminal Procedure Code permits a private person to arrest someone in certain circumstances. For example, if the person is caught committing an offense, or to prevent escape of an offender. But that power is more narrower than police powers and must still be reasonable and lawful. That means if you see somebody stealing something, you have the authority to arrest that person and or hold that person until the police comes and takes custody of that person. Or if you see someone generally committing an offense, a crime that is listed under the law, you have the authority of detaining that person. Then we also have the preventive or administrative detention, but this is only in very specific situations. For example, um, limit it can be limited to a public order or public health exceptions that are specifically provided by the law. Um, for example, you've heard about preventive arrest. Someone is about to do something, and then you hold them. For example, we have examples of some political parties where they do the preventive arrest so that that person does not actually commit the crime that they suspect is going to be committed. So those are the circumstances under which someone can, rightfully or lawfully be arrested. However,
Okay. Thank you. Thank you, Council Faye. You had something else to say. I just wanted you, in the interest of time, to give us some rights. What are those rights that every suspect should be informed of immediately upon the arrest? And also, how can suspects or community members challenge unlawful arrest? Please be a bit fast. We started a little late, and I wish to open this platform to questions by 7:30.
thank you, Mary. The rights must the what rights must every suspect be told immediately on arrest? One, they are supposed to be communicated to in the language that they understand. They must be told the reason for the arrest, the specific grounds, and then they must be brought before a court as soon as possible, and in any case, not later than 48 hours from the arrest. They have a right to remain silent and not to be compelled to incriminate themselves. They have a right to legal representation. They have a right to be informed of the right to apply for bail and also challenge the detention, that is bail. Then they also have a right to notify a relative or a third party and to be detained in a place authorized by law. Usually, that is at the police station. Yes. So, shortly, those are the rights of every suspect.
Okay, thank you. Um, Daniel, are you there? Daniel, could you please explain
Yeah.
what the presumption of innocence is? Most people have been hearing presumption of innocence. It has been talked about throughout the week. But what is the presumption of innocence, just in the practical terms? And why is this principle very important in preventing wrongful conviction? Daniel Olakomboni, over to you.
Thank you so much, people here and the coordinator, Council Mary. Thank you so much. Presumption of innocence. Every time you hear anyone, I must say that everyone is aware of what this principle is. Definitely, they may not know the detail. Now you have the chance to understand it in the simplest explanation. Presumption of innocence simply means that they have not yet we are saying we are suspecting you. We are thinking you might have committed the crime. And that is the reason why now we are talking about presumption of innocence. We are just saying that we are thinking you've committed a crime because the law says until we get evidence, until there is enough evidence to convict the suspect, we cannot say this suspect has committed the crime. We're just arresting him. That is a presumption. And the law provides this very well under the Constitution of the Republic of Uganda, Article 28, Clause 3, that in every criminal offense somebody is accused of, they must be presumed to not have committed any crime actually. Until they are presented in court, evidence adduced satisfactory enough, then we can convict them. That is the meaning. And cases have been decided in court, but the most famous case is the case of Wilmington versus DPP. In this case, there was a man and a lady who were in a marriage. They had issues with their marriage, and then the woman went back to their fathers, their home, and then the man felt like he wanted the lady back. He packed his gun, he moved to the lady, and then something happened, and he shot the lady. And then when he was taken to court, he was told that he shot the lady, and therefore he's supposed to be convicted. He was asked to prove that. But then the most important thing is when you go to court as a suspect, you're not the one supposed to prove. Now, the presumption of innocence now give birth to what we call the burden and standard of proof. All this comes in. Now, if you're a suspect outside there, if you're a criminal outside there, and you've been arrested, presented to court, don't quick of saying, what am I going to do? What do I use to prove myself innocent? No, that's not your work. The work is entirely on the prosecution to prove the case beyond reasonable doubt that you're not actually innocent, that you actually committed the crime. If they cannot do that, then please, you are supposed to be released. And that is the reason why sometimes you find people are in remand. Every time the case is, the prosecution comes and said, Your Honor, we have no evidence, we are still finding this, the police are still making this file, they're still finding this evidence. The reason is the burden is too high on them for them to prove that you've committed the crime. I think this is the simplest explanation of presumption of innocence, I would say. Unless otherwise there's any other thing, I would like to stop here. As simple as that, Council Mary.
Thank you, Daniel. Ola. So, in other words, you are presumed innocent until proven guilty. Everybody is presumed to be innocent until they are proven guilty. On that note, Edith Kawategeki, could you kindly take us through bail? If somebody is presumed innocent, then if they've been arrested, they should be out on bail until they prove them guilty. So what is bail? And why does court sometimes deny bail? Yet we know that it's a constitutional right. Article 28 of the Constitution, specifically Article 28.3, is on the presumption of innocence. Why sometimes people are denied bail? Edith, the floor is yours.
Thank you so much, Council Mary. I'd like to take it straight away to, I think, the key things. First of all, we need to understand that a bail is a constitutional is a constitutional right provided for under Article 23, Clause 6 of the Constitution, and it is simply an agreement between court and the person who applies to court, whether they have surety or not. So normally, bail is put there to release someone and ensure that they come from home while they appear in court. They do not have to stay in prison establishments while appearing before court. And normally, the reason for bail is to ensure that the right to liberty of someone is not violated, and also while exercising this duty of law enforcement officers of arresting criminals and making sure that these people who have committed such crimes are out of the society, it is important to consider other people's rights. For example, if let's say someone is arrested, a father is arrested, and he or she is a breadwinner, and the whole family simply relies on them. In as much as they might have committed an offense, sometimes court considers the rights of others, which people are depending on them, what will happen to their family. So in such circumstances, court can actually grant the person bail. And bail usually is granted where you have sureties. There has to be security. You give to court and people who are there to ensure that, you know what, you're releasing this person, but we're going to ensure that this person comes back and appears before court on the exact day and time they require them, or they need them to be in court, and to ensure that they do not run away when they are needed to appear before court. Yeah, and the other question was the reason as to why sometimes court denies bail. There is a perception out there that, you know, bail is a must, bail is compulsory, but legally it is to the discretion of the court. The court has the power to decide whether to give you bail or to deny you bail, and most times it depends on the gravity of offense. So looking at cases like misdemeanors, small offenses which do not take punishments exceeding 3 years, court usually is not hesitant to grant people bail. But if someone has committed an offense, like a grave offense, like let's say capital offenses, or they have committed treason, it is key. Court usually takes in key considerations to ensure that this is a very risky situation. Releasing this person out there might be a disadvantage to the society. So it looks into it. There are key factors they consider. Let's say if someone's health is at stake, if they are the breadwinners, or like I've said, if the offense they have committed is not that grave, they can not be hesitant to release such a person on bail. So, Council Mary, unless there are further questions, I believe I've answered all that has been asked. I'd like to stop there.
Thank you, Edith. Just give us, in brief, what factors do courts consider? Just in brief, highlight when they are determining whether to grant bail or not. What factors do the courts consider?
Oh, thank you so much. So one of the factors they consider, I have I think talked about in brief. It is the gravity of the offense. It should not be some a big offense or a capital offense or a misdemeanor. The court will consider a way in between if the offense is great. Then the other is if the status of the person. For example, there is a case where an MP was arrested and he could not attend court proceedings for his constituency. He kept on missing. So when he applied for bail, court considered that because he was missing out representation in parliament. Court considered that and had to release him on bail. Also, if someone is a breadwinner or if someone is sick, court will look into that because the rights of other people are at stake because this one person is in prison establishments. So summarily, those are one of the things that considers.
Thank you very much. In the interest of time, back to you, Daniel. Quickly before we open the floor for Q&A, Edith talked about misdemeanor. Could you distinguish a felony from a misdemeanor? Let us understand what is a felony, what is a misdemeanor, in simple terms. Daniel is not in. Edith, you can expound on that, the difference between a misdemeanor and a felony. Kindly enlighten us.
Sorry, thank you so much. So misdemeanors are simply those offenses that they're normally referred to as minor offenses whose punishment does not usually exceed 3 years. And while felonies are those offenses whose punishment normally exceeds 3 years. That's simply it.
So in other words, I need examples. Just give me a few, 2 or 3 examples for our audience to clearly understand. You've talked about the years, 3 years, and some of the people here are not lawyers. Examples.
Oh, thank you so much. So, let's say I'm giving an example of felonies. Felonies could involve crimes like, let's say if someone has been charged. Felonies also, we could take capital offenses among them. Capital offenses are these offenses whose maximum sentence can actually be a death penalty, because their punishments are usually more than 3 years. They include aggravated robbery, murder, yeah, things like that. And they also, even theft can be a felony because its punishment can be more than 3 years. And misdemeanors are usually minor offenses, and they could include offenses like simple assault. If someone has it's usually termed as simple assault. It could also amount as a misdemeanor because its punishment could be less than 3 years. Yeah, so basically that's it, council.
Thank you very much. Faith, Council Faith, are you there? Just a few enlightenment on children in conflict with the war. The children's rights, how are they protected during arrest and detention? Is the question clear?
Yes, it's clear.
Okay.
How children's rights are protected during arrest and detention in Uganda? Uganda's laws treat children, anyone below 18, as a special category requiring protection. Arrest and detention are only used as a last resort and only for the shortest time possible. So the key protections include that the arrest must be as a last resort, meaning police must avoid arrest unless absolutely necessary. For example, where the child is violent, cannot be traced, or possesses a serious danger to others. The law promotes diversion, that is, handling the matter outside court through counseling or release to parents and the guardians. The second protection is children must be handled in a child-friendly manner. Um, the police officers must identify themselves first of all. They explain to the child, they explain why the child is being apprehended, and they treat the child with utmost dignity. They are not supposed to use force or violence except um, as a last resort and strictly proportional to the child's, age, the size of the child, proportional force if necessary. And then the third one is immediate rights upon arrest. So the child must be informed immediately in a simple language they understand why they're being arrested, the usual. The right to remain silent, the right to have a parent or guardian present, the right to a lawyer or state provided legal representative. Usually, legal aid in juvenile cases is strongly emphasized. Um, and then also the parents must be notified at once. And then we have strict limits on detention. A child must not be detained with adults. You cannot mix a child with an adult in the prison. And then detention can only be in a gazetted remand home. Children are not supposed to be detained in police cells or normal prisons, or military facilities. So the police must release the child on bond where appropriate. You're supposed to produce, police is supposed to produce the child before a family and children's court, that's called an FCC, within 24 hours and not the usual 48 hours for adults. So the shorter timeline is because detention is more harmful to the child. And when we look at our laws, we are always looking at the best interests of a child. Then police is supposed to protect the children from torture, harassment, or intimidation during an arrest or detaining. The child must not be subjected to threats or harsh interrogation, coerced confessions, slapping, beating, humiliation. So any evidence obtained through such means is invalid. The children have a right to privacy. The child's name, the image of the child, the details cannot be published in the media. And then the proceedings are supposed to be held in camera. In camera, I mean it must be closed court. Just maybe the child, the presiding officer, the police officer, and maybe the parents. Then there is also immediate access to family and lawyers. A parent of this child must be present throughout the entire process. If no guardian is available, a child has a right to have a probation and social welfare officers present to protect the child's interests. Then a detained child must have access to basic health care, counseling, food, and basic sanitary conditions appropriate to their age. Detention conditions must be humane, child sensitive, and free from abuse. Then, lastly, before taking a child to court, authorities must first consider counseling the child, mediation, community service, um, formal police caution, and then referral to social welfare programs. So, court proceedings in such instances should be the very last option in case of a child. Thank you very much. I hope I have answered
Thank
that
you.
question.
Thank you, Council Faye. It is 7:33. I wish to open this session to the public. You may ask any question of your choice. Panelists, please take note. I will be asking the participants to ask questions, but we could probably first look at what has been asked in the chat. I would like to know more about Interpol. This is WOMO Innovators. Interpol, that is International Police, and Interpol is a department in the police structure, the Uganda police structure. They are directly under Ministry of Internal Affairs. In Uganda, they sit at Kololo, and most of their work involves having liaison or relationships with other countries, and they assist to identify criminals that are hibernating within Uganda. Beyond that, they also do other services like clearing those who are traveling out of the country. You've heard about a certificate of good conduct. So they issue that certificate of good conduct, and it is normally required by the foreign companies. It registers crimes, it registers fingerprints and biometric, such that if you have committed a crime, then that certificate of good conduct will be able to show that there is a problem. They deal with cybercrime, they handle human trafficking, they handle travel documentation, they handle a lot of things. If there is an issue with a stolen vehicle, they usually do such checks. They handle clearance of lost passports. So if Interpol gives a verification on a lost passport, then a foreign country will rely on that. So basically, in brief, your question was general or mono. If you have a specific question on Interpol, you can ask, but generally, that's what they do. Another question that came through, Emmanuel is asking, do they count day and night as 2 days, 12 hours, or it's day or night as 1 day? I would like to know what the capital offenses are. Edith, I think you will need to take note of that. What are the capital offenses? Or Daniel? Okay, I'll get back to the question. I saw Joanne. Joanne, you had your hand up. Would you like to ask a question?
Yes,
Okay, please do.
my question goes to Council ADS. Are there instances in can show some gestures or whatever What procedures does the court consider to get evidence from such children?
Thank you very much, Joan. Counsel Faith, please prepare to answer that question. Joan would like to know the procedures that court takes to pick evidence from persons with disabilities. She has specifically mentioned those who are deaf or mute. Take note. Any other question? There's a question in the chat. Faith, as you prepare to ask that to answer Joan's question, there's a question. Suppose I'm arrested for any case and law states that I must be taken to court within 48 hours. Then suppose I'm not taken to court within 48 hours. What should be my next step? What should I do? Edith, prepare to answer that question. The 48-hour rule. I hope it is clear. It's in the chat. You can check it and get more clarity. Any other question? Okay, Counsel Faith, could you answer the question on children? And Edith, prepare to answer the question on capital offenses and the 48-hour rule.
Okay, taking evidence from a child with a disability, such as a deaf child, like you had said, requires special procedures to ensure the child's rights are protected and that the evidence is accurate and admissible. So you'd need to use a qualified interpreter. The court or police must provide a qualified sign language interpreter for this child, who must be neutral, a certified person, someone the child understands and is comfortable with. Then you need to conduct the examination in a child-friendly environment. Children with disabilities generally may experience stress faster, the asking of the questions and all that. So it needs to be in a quiet and private room. You need to ensure that the child understands the difference between the truth and lies before taking evidence. So we also need to, depending on the child's abilities, evidence may be obtained through sign language, writing, that's if the child can read and write, drawing or pictorial tools, alternative and argumentative, no, argumentative communication like picture cards, digital devices, gestures, visual boards. The method chosen must match with a child's communication ability. So basically, a child with disabilities needs someone they're comfortable with, someone they understand, and someone who is familiar with their disabilities. Thank you.
Okay, thank you, Counsel Faith. Edith, there are certain questions that were meant for you. Presumption of innocence.
Well, thank you so much, Council Mary. If I recorded well, I think one of the questions that was asked of me was someone wanted to know what amounts to what capital offenses are, and the other wanted to know the 48-hour rule. In case they're not released in 48 hours, what do they do? I hope those are the questions I am answering. So, first of all, capital offenses are those very serious criminal offenses, and usually these capital offenses are punishable by death or life imprisonment. Like their maximum sentence is usually a death penalty. Yeah, and these capital offenses under the Penal Code Act include murder, aggravated robbery, treason, or aggravated defilement. And maybe you'd love to know what this, especially, let me just highlight on aggravated defilement, because you'd wonder what is defilement and aggravated defilement. Defilement is where, like, the person who has been defiled is below 14 years of age, or if the offender or the defiler is, let's say, HIV positive, or if the offender is a guardian, a teacher, or someone in authority. And
I'm going to call you back.
if the offender uses if the offender uses violence, and where multiple offenders are involved in this kind of defilement. Yeah, so offenses like aggravated defilement, rape, terrorism, where someone is kidnapped with intent to murder them, smuggling firearms, or aggravated firearm offenses. Such offenses amount to capital offenses. And maybe knowing about the jurisdiction of capital offenses where they are tried. Capital offenses are usually tried, only the first court you can go to is the high court. You cannot be tried in a magistrate's court or in a chief magistrate's court. Yeah, so you are taken to the high court. In the first place, you can appeal to other courts, court of appeal or supreme court afterwards. And in capital offenses, bail is usually restricted, like I earlier explained. Considerations for granting out bail: when someone has committed such capital offenses, it is really of a disadvantage when you look at it. Releasing such a person on bail, they are not yet proved guilty, but it is a risk to the society. What if they go back and commit the same crime? So court is usually hesitant to release people on bail who have committed capital offenses. I believe I've exhausted that question. Council Mary, can I proceed and answer the other, or would you like to?
Yes, please proceed and answer the other question.
Okay, thank you so much. So the other question was asked by Michael. I can see in the chat box. Yes, if you're not released within 48 hours, what do you do? Yeah, so the key things to do is, first of all, you know that the 48-hour rule is a constitutional right. You are not supposed to be detained in custody for more than 48 hours without being brought to court. So what do you do in case you're detained? First of all, you can demand police that, you know what, I've been detained for 48 hours, grant me a police bond, let me go on police bond, because it is my constitutional right. Or if you cannot, your relative or anyone close to you can remind OC, talk to them, or apply or ask for the police bond to be granted to you. The other is, you could talk to your lawyers. You contact your lawyers and talk to them about applying for what is called the writ to habeas corpus. The writ to habeas corpus simply means that present the body to court, whether dead or alive. And when your lawyers have done that, you'll have to appear before a judicial officer, that is a magistrate or a judge, and be brought out of prison. Then they can determine what is to be done to you afterwards. Yeah, so those are the key two things that you can consider in case you are not released within 48 hours. Yeah, so summary, I think that's it.
Thank you. There is another question. I will allow Council Faye to answer that question, closely related to what Edith has just been talking about. And Florence is asking, my sister's husband was arrested around August. He was suspected of being part of a murder case, but ever since he asked for bail, he has not been responded to. He is the breadwinner at his home. What do you do in that case? He's just in prison, no hearing from court, no nothing. My sister is so frustrated, and it's November. Council Faye, over to you.
Okay, Florence, first of all, we are really sorry that your sister and her family are going through this. The clearest and most practical guidance on what can be done immediately is, first of all, if he has been in prison since August to November with no hearing, is a violation of his right to fair and speedy trial. Like Edith earlier explained, what you can do immediately is to apply for a writ of habeas corpus. And in your situation, this is the most powerful remedy when someone is being held without progress. The lawyer can file it in the High Court, and the prison authority will be ordered to produce this person and explain why he's being held. Yes, so habeas corpus is especially useful when there is a necessary delay, bail has not been had, the person has been forgotten in the system, and when you make this application, a judge will order for his immediate production, immediate hearing of bail, and even release if he is being detained unlawfully. Yes, the other procedures are, go to the High Court, the Criminal Division, and follow up on the bail file. And most importantly, contact a lawyer to help you with this entire process of bringing this person to be arraigned in court. Yes, that is the short explanation that I can give to you, Florence.
Thank you, Council Faye. Council Faye, I think this issue falls under our pro bono scheme. Could you consider taking Florence's number and we help the sister? This is a matter we can take under our pro bono scheme. Okay. There is a comment from Stephen. Stephen says, for dump witnesses admissibility, the procedures are provided for under Section 118 of the Evidence Act. Council Joanne. Okay, thank you for that. Stephen, you must be a lawyer. Thank you. Okay. Yeah, Florence has made a comment. Thank you, Council Faye. I'll let my sister know. Thank you. Do we have any other questions? Council Faye, could you share your phone number so that those that wish to register pro bono criminal aspects at TMBEI advocates, majority are handled on pro bono service. So Council Faye, please share your number in the chat. Great. We'll be in touch and discuss further. Any other questions? Okay, as we wait for questions, Daniel, are you still with us? Council Faye, yes.
Yes, this is not a good one, but it's an appreciation from Behamia Michael. He says thanks to Edith for the way she answers the questions.
That is great. Thank you. Thank you, Michael, for appreciating, and for the rest of the team. Thank you, Edith, for that great response. We highly appreciate the feedback. Thank you very much. Okay. Any more questions? Daniel, you're around. Daniel, I need you to talk to us. Give us some insights in regards to, just give me a minute, I had a question that came through. Yes, someone wants to understand the common forms of fraud or false pretense that occur in our communities. The question is as broad as that. What common forms of fraud or false pretense occur in our communities? Would you like to answer that, Daniel? Okay, Daniel, as you rethink, another question has come in. Good day, Council. My brother was involved in an accident last year, August. He was in coma for weeks, and on recovery, he was mentally unstable. One person died in the accident. The car impounded at police. The family of the deceased are asking for 4 million compensation. My brother is handicapped now with 4 kids dependent on him. Are there any remedies? Council Faye, would you like to answer that question?
Yes.
Okay, thank you.
Um, I'll explain it in simple terms, but with maybe like an accurate legal grounding under our laws. The um, the possible legal issues at hand are criminal liability, that is causing death through a rash or a negligent act. This offense falls under the penal code, and um, you are liable to imprisonment of over about 2 years. So, given your brother's mental incapacity after the accident, this is very important for his defense. The deceased family may lawfully seek compensation for loss of dependency, the funeral expenses, pain and suffering, and then loss of expectation of life. But such claims are normally handled through a civil negotiation or court and not police. The remedies available in this situation are: one, plead mental incapacity. That's a mental defect defense. If your brother was mentally unstable at the time of the accident or is still medically unfit, this can be raised under the Penal Code Act as an insanity defense, and also the Mental Health Act. So um, get a psychiatrist or a doctor's report confirming his mental and physical condition, and that report will protect him from being mishandled legally and also support his plea of reduced or no criminal liability. Number two, this offense causing death by negligent act is compoundable under the law when both parties agree. That is, the demand for 4 million is not illegal, but you have rights to negotiate the amount because your brother is disabled, he has dependents, his income is affected. Yeah, and police cannot force you to pay a figure you cannot afford. So you can negotiate for payment in installments, a lower amount, delayed payment timeline, etc. Third remedy is check if the vehicle was insured. If the vehicle had a third party insurance, it can cover death of a third party. So we pay for third party, but we forget its use. We just think it's an obligation. So under in third party insurance, you can claim even up to 10 million for a fatal accident, depending on your insurance company policy. Um, the fourth remedy I can give you is bail or release on police bond because he is disabled, he's financially responsible for his children, he's mentally unstable. So he's an ideal candidate for a police bond or court bail because he's vulnerable. The fifth remedy I can give you is to request court for a lenient sentence that is called mitigation under the law. If this matter goes to court and he's convicted, his health can re- the his health situation can reduce the sentence drastically. Yes, I hope I have answered that well. Council Mary, over to you.
Thank you, Council Faye. Yeah, there's a question that came in: the forms of fraud and false pretense. Daniel, are you able to respond? Daniel seems to have an issue with the network. But some of the forms of fraud that we can consider, there is mobile money fraud, and it's happening everywhere. Fraudsters are quite many. I have seen TikTok videos where someone just appears at the mobile shop, pretends to be taking money, and then when the mobile money agent, turns to pick something, they place their hand. But there is also where they are sending money and it actually doesn't go through, but you receive a message to show that money there has been a transaction, when that message has actually just been hand typed. So there are several scams that are happening. There are people where they call you, inform you how they are from MTN